Hello and welcome to another episode of Currently Speaking. I'm Bill Current, president and founder of the Current Consulting Group. And if you would like to listen to past episodes of Currently Speaking, go to our website at currentconsultinggroup.com. You'll find an archive of all of our past episodes, as well as past webinars that we've done and blog posts that we've published. And you're free to peruse those and listen to them and read the articles. So we invite you to share it also with others as well. So that everybody can be aware of these great podcasts and webinars that we've done in the past. So in a recent 30-minute webinar series, we call them Current and 30, I presented a webinar titled Addressing Marijuana in Your Drug Testing Policy, Complacency Is Not an Option. Now, during the webinar, we covered a lot of ground, including new state legislative developments, the importance of having a well-written drug testing policy, and the growing focus on workplace impairment. Unfortunately, we ran out of time before we could get to any questions. So in this short podcast episode, I'd like to take a few minutes to answer some of those questions. And if you'd like to watch the full webinar presentation that we did, we'll provide a link to the recording at the end of today's podcast episode. So, first question. One of the first questions many employers ask is this: if marijuana is legal in a state, can employers test employees for marijuana and take action if they test positive? Well, the answer is yes, generally. Testing for marijuana is actually permitted in all 50 states, including those that have legalized the recreational use of marijuana. However, and that's a big however, there are some states that restrict and some that severely restrict when testing may occur, and in 2 states, how testing for marijuana may be conducted. So I'm going to share a couple of examples, but first let me emphasize, or maybe more accurately stress, the critical importance of understanding the state laws that apply to your company. And if your company has operations in multiple states, you must comply with the drug testing and marijuana laws of all of those states. So here's example number 1, New York. Many people would say testing for marijuana in New York is strictly prohibited. And a cursory review of the state's Department of Labor guidelines on marijuana and the workplace would appear to justify that assumption. But a careful study of all applicable regulatory language in the state opens up the possibility, a slight possibility, of being able to test for marijuana in very limited circumstances. So in response to the question, can an employer test for cannabis, the state's Department of Labor guidelines state, quote, no, unless the employer is permitted to do so pursuant to the provisions of Labor Law Section 201D4A or other applicable laws. Labor Law Section 201D4A, we're talking about the state labor law, states, quote, notwithstanding the provisions of subdivision 3 or 4 of this section, an employer shall not be in violation of this section where the employer takes action related to the use of cannabis based on the following. 1. The employer's actions were required by state or federal statute, regulation, ordinance, or other state or federal governmental mandate. 2. The employee is impaired by the use of cannabis, meaning the employee manifests specific articulable symptoms while working that decrease or lessen the employee's performance of the duties or tasks of the employee's job position, or such specific articulable symptoms interfere with an employer's obligation to provide a safe and healthy workplace, free from recognized hazards as required by state and federal occupational safety and health laws. Or 3, the employer's actions would require such employer to commit any act that would cause the employer to be in violation of federal law or would result in the loss of a federal contract or federal funding. Hence, it is lawful for New York employers to address marijuana use in the workplace and under some circumstances, very limited circumstances perhaps, even test for marijuana. Clearly, the window of opportunity is barely open, but it is open a smidge. Employers should consult with a drug testing expert prior to testing for marijuana in New York. Ensure their drug testing policy aligns with the restrictions imposed by the State Department of Labor, and ensure supervisors and managers understand when it might be lawful to test for marijuana in New York and when it probably is not lawful. Now, for our second example, let's talk about California. Is testing for marijuana in California permitted? The answer is yes. However, Employers in the Golden State are prohibited from discriminating against applicants and employees who are legal marijuana users based on, among other things, a positive drug test result from a testing method that only reveals the presence of the so-called non-psychoactive metabolite of cannabis. Testing methods that reveal the presence of the psychoactive form of the drug, often referred to as the parent drug or parent THC, are permitted. Now, the construction industry is exempt from the restrictions of this law. This means that construction companies may still test for marijuana using a testing method that only reveals the presence of the metabolite of cannabis. California employers may still test for marijuana, generally speaking, but they cannot take adverse employment action against someone who tests positive unless the test shows the presence of parent THC rather than the quote-unquote non-psychoactive metabolite. Urine testing, which typically only reveals the presence of the non-psychoactive metabolite of cannabis, is no longer permitted in California when testing for marijuana. Oral fluid testing, on the other hand, which detects the presence of parent THC, would be permitted when testing for marijuana. Section 1C of the law states, quote, as science has improved, employers now have access to multiple types of tests that do not rely on the presence of non-psychoactive cannabis metabolites. These alternative tests include tests that identify the presence of THC in an individual's bodily fluids. Importantly, the law further states, quote, this paragraph does not prohibit an employer from discriminating in hiring or any term or condition of employment or otherwise penalize a person based on scientifically valid pre-employment drug screening conducted through methods that do not screen for non-psychoactive cannabis metabolites, end quote. Hence, the nod to oral fluid testing. Another question relates to impairment. If a positive drug test does not necessarily prove impairment, how can employers demonstrate that an employee is impaired while working? Well, the answer to this is kind of complicated, but it's important to understand that a positive drug test result does not prove, either legally or scientifically, that the donor is or was impaired at the time of the test. However, it does prove the person had illicit drugs in their system at the time of the drug test. And that should be a violation of your company's drug testing policy. Drug tests reveal the presence of drug in a person's system in what is known as nanograms per milliliter. You've probably seen it in writing as lowercase ng / lowercase m capital L. The cutoff level of nanograms per milliliter, above which a person is considered positive or negative, depends on the drug and whether the test was an initial screen or confirmation test. In Part 40.85 of the federal regulations, you'll find the federal cutoff levels. For instance, the cutoff level for marijuana is 50 nanograms per milliliter for the initial test and 15 nanograms per milliliter for the confirmatory test. Unfortunately, there's no national standard at which a marijuana positive test result proves or indicates impairment, like there is for alcohol, for example, which is on a national level 0.08% blood alcohol concentration in most states. Utah is an exception at 0.05%. However, we know, according to an international report out of the University of Sydney, that marijuana impairment can last from 3 to 10 hours depending on a variety of factors, including how a person consumes marijuana, the potency level of the marijuana used, and the type of work being performed. So someone who shows up to work or returns from a lunch break smelling of marijuana and or acting in some abnormal way may be impaired. A positive oral fluid test result combined with the documented aberrant behavior may not prove the person is impaired, but likely provides the employer with sufficient evidence to justify some type of adverse employment action. Because the oral fluid test is capable of detecting drugs in a person's system within minutes after they've used the drug. Whereas with urine, there's about a 6 to 7 hour gap, give or take, from the time the person uses the drug before it becomes detectable in a urine sample. One other thought would be to conduct a non-drug test impairment exam. Impairment detection technology is becoming more commonly available and a great addition to a drug testing program, especially in safety-sensitive industries. Here's another question we often hear, which is whether companies should consider dropping marijuana from their drug test panel altogether. particularly in states where marijuana has been legalized? What risks should employers consider before making that decision? Well, this is only a personal opinion, but in my opinion, the only reason to discontinue testing for marijuana is if you don't want to know who the drug users are in your employ, or you just want to hire more drug users. Three things will happen if you stop testing for marijuana. First, you'll hire more drug users, more marijuana users. Second, you'll see an increase in marijuana post-accident positive drug test results. And third, you'll likely see an increase in workers' compensation claims being filed. A fourth unfortunate consequence of dropping marijuana from your drug test panel is you may expose your company to increased legal liability. For instance, if you hire a person to drive a delivery van, but fail to screen that individual for marijuana, and it turns out he's a daily marijuana user who applied for a job with your company because he heard you don't do pre-employment drug testing, especially for marijuana, then goes on to cause an accident while operating your company's vehicle, well impaired by marijuana, you, the employer, will be responsible for the damages and harm caused to others. A doctrine of law known as respondeat superior means that you are responsible as the employer for the actions of your employees when they are functioning within the scope of employment. Hence, the accident he caused could have been avoided entirely if you had conducted a pre-employment test that included marijuana. You would have known not to hire that person to perform a safety-sensitive job. Maybe you would have hired him to do something else, but not drive a delivery van. But because you didn't screen for marijuana, your company will likely be held liable for the result of the accident he caused. Fourth question. Another important issue is how often employers should be reviewing or updating their drug testing policies, given how quickly marijuana laws are changing. That's a great question because here at the Current Consulting Group, we write drug testing policies, and we're often working with a company that has not updated their policy in years. Unfortunately, because marijuana laws and state drug testing laws are constantly changing, new laws are being introduced and passed and enacted, it's imperative that you update your policy on a regular basis. If not in real time, at least annually. And certainly annually, you should have your policy reviewed to make sure that it still aligns with your corporate priorities and that it complies with all applicable state laws. One of the questions that we get asked all the time is, we're in multiple states, which law do we base our policy on? Unfortunately, you must comply with all of the state laws that apply to you. So let's say you're in 30 states, including California, which is very liberal in its drug testing policies, and Florida, which is much more conservative. You don't want to create a policy that you base your entire company, all 30 states, on California if you want to, say, conduct random drug testing, which is frowned upon in California due to case law. So maybe you base it on your home state, wherever that may be, but you have individual state addendums to cover state laws that apply to you that have different regulatory requirements than your home state. So you might have, for a 30-state company, it would be very rare to have, say, more than a half a dozen to a dozen addendums. You might have that many, especially with the marijuana laws as they are. But you want to review your policy regularly, including as it compares to all the state laws that apply to you, at least on an annual basis, if not changing your policy or updating it in real time. There was a change to the laboratory licensing law in Minnesota that now makes it possible for employers to use rapid result or point of collection oral fluid testing. That was a major change in Minnesota. There are examples like that every year in multiple states. In fact, at Current Consulting Group, we track the state laws and the legislation. And in 2026, we have seen probably over 500 bills introduced at the state level, many of them marijuana related or other types of drug related laws. But if passed and enacted, would have a direct impact on a company's drug-free workplace program and its drug testing policy. So it's very important that you stay up to date. If we can help you, we're here to do that. You can subscribe to our state law database called Current Compliance, and that will also entitle you to receive our monthly legislative updates called Leg Up. as well as real-time memos whenever a new law is passed and is about to be enacted. So if you're interested in that, go to currentconsultinggroup.com. You can find a demo of current compliance on there and then information on how to comply. But those were the questions that we couldn't get to the other day. We are anxious and willing anytime to answer your questions. So email us, call us, and let us know of any questions you have related to drug testing, about drug-free workplace policies, on the marijuana issues as it affects the workplace. We'll be happy to provide information for you. That concludes this episode of Currently Speaking. We invite you to go to our website at currentconsultinggroup.com, where you'll find past episodes of Currently Speaking, as well as past webinars and blog posts that we published. You're happy to peruse those and enjoy them and learn from them. And please share the availability of these great podcast webinars and blog posts with others so that we can grow our audience and get this information out there. Thank you again for joining us. We'll catch you on another episode of Currently Speaking in the near future.